Harbor Cove versus Joseph Alleman.
Oh my God.
This case starts exactly how many eviction cases end, with silence from one side. No defendant, no response, no defense. And in a courtroom like this, that silence is interpreted as surrender. The judge doesn't chase you down. The court doesn't wait. If you're not here, the system moves forward without you. What you're seeing is the legal equivalent of a walkover. The plaintiff's attorney walks in prepared, numbers ready, statements aligned, and there's no one to challenge any of it. That creates a one-directional outcome where the judge only has one version of events to rely on. And notice how quickly this unfolds. Within seconds, the court is already moving towards sworn testimony. That's the speed of eviction court. Efficient, procedural, and unforgiving. Behind this calm exchange is a high-stakes reality. Someone's housing situation is about to be decided in under a minute. No argument, no negotiation, just documentation and absence. Here's the key tension. How many people lose, not because they're wrong, but because they didn't show up? This opening moment sets the tone. This courtroom rewards preparation and punishes absence immediately.
Good morning, Your Honor. Joe Horka appearing for Harbor Cove.
It's late.
I don't know who that is either. Joseph Alleman. I have no response. You have them checked in?
No, I do not.
We don't have them checked in. Would you like to proceed?
Your Honor, this is a subsequent hearing date. It's a non-payment of rent case, possession only. I'd be seeking a default judgment, please.
All right. Raise your right hand to be sworn. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. You may proceed.
Your Honor, I've been presented with a ledger by my client that indicates the rent to retain is $1,718. The Attorney Records Office has calculated statutory attorney fee and court costs of $225 for a total balance of $1,943. My knowledge, the defendant does not serve in military, doesn't have a disability that would keep them from appearing here in court here today, and the property's been kept in reasonable repair and condition.
Judgment to the plaintiff by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Thank you.
Thank you.
Valley Ranch versus Nidell Hamden. They're both on, right?
Just 13.
Good morning, Your Honor. Christopher Borkin for the plaintiff.
Morning, Your Honor. Nidell Hamden here.
All right, gentlemen, where are we on this case?
Your Honor, unfortunately, negotiations did break down with the extra term the defendant wanted to add into the agreement. I was not able to review that agreement. I understand it's in the court file. My signature on it is not valid. That was submitted without my permission. The term on there that is the issue is that the amount in escrow would be attributed solely to August. There is a balance remaining, Your Honor. $1,878, including court costs, is the amount owed to date. That is after the defendant claims that they paid July rent.
Now we're stepping into a completely different dynamic. Both sides are present, and suddenly the case becomes a negotiation battlefield. The attorney is laser-focused on one clause: how escrow money is applied. That might sound minor, but legally, it's everything. Why? Because how payments are allocated determines whether the tenant is considered current or still behind. One line in an agreement can decide whether someone keeps their home or loses it. But then comes a serious claim. The attorney says their signature on the agreement is not valid. That's a direct attack on the credibility of the document itself. If proven, it could invalidate the entire deal. This is strategic lawyering. Narrow the dispute. Control the narrative. Focus the judge on a single decisive issue. At the same time, the total owed is repeated: $1,878. That number isn't just information, it's positioning. The more it's said, the more it becomes the anchor of the case. Here's the real question. When agreements fall apart like this, is it about misunderstanding or deliberate positioning by both sides?
There was an amount at issue here that is not resolved just by my client waiving late fees. I would request that the court would find no triable issue.
Mr. Hamden, what do you have to say?
All right, sir. So I have a dismissal case on this back in February. I think you have a copy of it, which is on page number 5 on your file I sent to the court.
Okay, what is your point?
Well, there's a dismissal on the case, so I don't know why we are in court again.
The case wasn't dismissed, and even to the extent that it might have been dismissed, it was dismissed without prejudice, so it can come back.
Okay, so my thing is, this is the whole case. My rent a month is $18.41 times 12. That's $22.92.
Sir, how much do you claim you owe?
I don't owe them any money, sir. The reason why they
Here's
have,
what I'm gonna do. Give me a trial
sir,
date.
can I explain something? Can I
Give
explain
me a
something?
trial date. Well, let's do it soon because this is,
Well, the next week is our trial week. We can do Wednesday the 26th,
at what time? In person.
9 a.m.
Sir, I
26. Non-jury trial on this matter will be set
have
July
emergency, sir.
26th. Sir, do not interrupt me.
I have
July
an emer-
26, 2003, 9 a.m. That is in person.
This is where the judge draws a hard line. The defendant tries to interrupt, tries to push urgency, but the court doesn't bend. The trial date is set, and once that happens, the timeline becomes law. Notice how the judge responds to the interruption. Immediate shutdown. That's not personal. It's procedural. Courtrooms operate on order, and any attempt to disrupt that order is cut off instantly. The defendant claims an emergency, but the judge doesn't explore it. Why? Because at this stage, the responsibility is on the parties to manage their availability. The court has already provided time, already allowed for negotiation. Now it's execution. There's also a psychological shift here. Early in a case, there's room for discussion. Once a trial date is set, that window closes. Everything becomes rigid. And the repetition of the date and time isn't accidental. It's reinforcement. You've been told clearly when to show up. Miss it, and the consequences escalate fast. So here's the engagement point. If you were in that position, would you keep pushing back? Or recognize that the judge has already moved past negotiation?
All right, but I have an emergency. I cannot be at court at that day, sir.
I've set the trial date, sir. I've given you guys time. I had a final settlement conference. You guys were going to resolve it. You haven't. I've set the trial date.
All right,
26, 10 a.m. or 9 a.m. Thank you. Court calls the case of Jessica Ellenbogen versus Michael Rohane.
Ellis Freeman for the plaintiff.
As well as Natalie, is it Keniston?
Johnston.
They are not checked in. Would you like to proceed, Mr. Freeman?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. My name is Ellis Freeman.
Go ahead.
I'm the attorney and authorized agent for the plaintiff in this matter. These parties were served by Judy Bell. They appeared in court last week, said they had receipts, were told to bring them to court and to send them to me. I have heard nothing from them. I have no explanation for their absence. I would ask for the possession judgment in the amount of $8,600 in rent, $190.70 in cost for a total of $8790.70. Writ to issue.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with writ to issue in 10 days.
Thank you, Your Honor. Have a good weekend.
You do the same, sir. Wendra Meda versus Ephraim Jackson.
Good morning, sir. Gary Apps appearing on behalf of the plaintiff.
Yes, Ephraim is here.
This is a termination of tenancy case. And where are we on this?
Well, if I may, sir, since last hearing, I've learned some more stuff. I've never met my clients. It was just voices over the phone. Mr. Matha apparently is an older gentleman, and his son or son-in-law has been trying to help me. And I thought I asked the right questions. They told me that the property was not certified, and they were simply asking the tenant to move out. This is not their first time evicting them. The court dismissed the case previously without prejudice, and I'm not 100% sure why, but they asked me to go in. At the last hearing, the defendant said he had a lease. Well, I know in Kalamazoo County, if a property is not certified, the courts will not allow the lease to go forward. So I never got a copy of any lease, so I did not attach one to the pleadings. But whatever lease there may have been, if the property is not certified the way my client believes it isn't, then I don't think the lease is valid. And I don't know if that's a reason for dismissal with your court or not, but we're simply seeking possession of the property based on the fact that the property is not certified. So any lease would have been voidable at least, and probably void under today's conditions.
Well, and Mr. Jackson, what do you have to say to this?
Now, this is where the case turns into a credibility clash. On one side, the attorney is arguing the property isn't certified, which could invalidate the lease entirely. On the other side, the tenant insists there is a lease and that they've been trying to resolve the situation. This is a legal gray zone. If the property truly isn't certified, the landlord may not be able to enforce the lease. But here's the problem. The attorney doesn't have proof in hand. And the judge immediately zeroes in on that gap. It's not enough to say something in court. You have to prove it. Documentation beats statements every time. Meanwhile, the tenant is explaining attempts to pay, attempts to communicate. But without records, those claims carry limited weight. This is what makes courtroom disputes so complex. Both sides can sound reasonable, but only one side needs to prove their position. So ask yourself, if you were the judge, would you rely on statements or demand hard evidence before making a decision?
I do. We've been here to the court multiple times. So so the last time that we was here, I had to get a ledger balance and a contact Hawk. So I did all of that, but he never contacted me back about anything. And I do have the lease. And I don't remember last court date. He even gave me last court session or court case, he even gave me a copy of the lease. The lease ends it ends in October. So I don't know what.
All right, let me just ask this: has rent been paid?
I've tried to. That's the thing. I've tried to.
What's the last month you paid rent?
November
of 2022.
Yeah, and we've tried to come, and we've been to court in, I think it was the last court date was a couple months ago, and I was about to get it paid by Hawk, but he never sent me a ledger balance. I tried to contact him. I kept calling him, and I left the messages.
Okay. Hold on. So, counsel, how do I know this property is not certified? Because I think this is a Pittsfield Township property.
Well, Your Honor, I've been a lawyer 32 years and a landlord 43 years. I called the township to ask them, was there a certification requirement? They told me it was. I'd be happy to swear to this, and that this property was not certified. So based on that, and my client's telling me there was no lease, and I took it meaning there was not a lease, period. They may have thought the lack of certification meant the lease was void. So I went ahead and filed for simply a termination with no request for any money. I did look up the prior case that was dismissed, I think was back in April, was also a termination, and they only paid a $55 filing fee. So there was no request for a supplemental complaint on the prior case either. So we're simply asking for possession with, again.
But counsel, what do I have? I understand your indication, but what do I have as proof that the property is not certified? I mean, if this is a Pittsfield Township property, which it looks by the address that it is, they will give you written verification that it's not certified and hasn't been inspected, but I don't have that before me.
I didn't know. The first hearing was a week ago. I didn't know that was an issue, but I had called Pittsfield earlier. Had I realized I needed to submit something from Pittsfield, I would have done so. So I guess if that's going to be an issue, if the court would consider a brief.
Well, that's the basis, but that's the basis for your termination. What do you mean? Is it an issue? Your basis for the termination is that the lease is void or voidable, and that there really is no lease because the property is not certified. But I don't have anything to say that it's not certified. I don't know.
Okay, again, if I may have an adjournment, I'll get a hold of Pittsfield. I'll get whatever documentation.
July
done.
28th, 2023, 9 a.m.
Thank you.
Thank you.
This is a tactical retreat, and sometimes it's the smartest move available. The attorney realizes the case has a critical weakness: no proof that the property isn't certified. Without that, their entire argument collapses. So instead of pushing forward and risking a loss, they request an adjournment. That buys time. Time to gather documents. Time to strengthen the case. And the judge grants it, but with structure. A new date is set, and the expectation is clear. Come back prepared. This moment highlights something important about legal strategy. Winning isn't always about pushing harder. Sometimes it's about knowing when to pause and regroup. But there's risk here too. Delays can frustrate the court, and if the evidence doesn't materialize, the credibility of the attorney takes a hit. So here's the question: is delaying justice a smart strategy, or just postponing the inevitable?
You said what date? I'm sorry.
28th, 1 week,
9 a.m.
9 a.m.
All right.
Thank you.
Thank you,
Brian
sir.
Schumacher versus Ashley. Is it Bellick?
It is, Your Honor. David Bittner on behalf of the plaintiff.
Yes, sis.
Judge, this is
Miss Bellick?
Yes.
Okay, she is set. Got her. Okay. All right. What's the claim on this case? This is a termination case?
It's a termination case. There is no lease, Your Honor. She was there by permission for a period of time. She said 4 months. The property has been sold, and the elderly gentleman and his caretaker were to move in June 1st. She has drug her feet and will not leave, has threatened to take the appliances with her when she does.
Okay, can
Ms.
I speak
Bellick,
now?
what's your position on this?
This property was purchased for my mother by my stepfather, Brian Schumacher. Brian Schumacher never physically lived in this home. My mother told me that my son and I could stay here with her as long as I paid the rent and the utilities. She told me to let go of the rental home that I was in for 8 years, and because we could stay here. So I let my home go that I was in for 8 years because my mother said that we could stay here. There was no time limit ever given. And then Brian Schumacher and I do not get along. So when he found out that I was still here, he went and sold the property to his friend and showed up here saying I was trespassing and expects me and my son to be out on the street. So at this point, I've been searching for somewhere for us to move to. I would have never let go of the home I had for 8 years. We would have stayed there. My mother didn't tell me we could stay here. So I need some time to at least find somewhere for my son and I to go at this point.
Counsel, is there any room for any additional time?
No, Your Honor, the place has been sold. She was served personally by the sheriff, and they've been telling her.
Your Honor, the place is still in Brian Schumacher's name. It has not completely been sold. They have not put in the new person on the title yet. And I know that for a fact from my mother.
All right. Well, here's what I'm going to do. I don't find that there's a tribal issue. I'm going to grant a judgment for possession after hearing on this matter.
This is the moment everything becomes final. The judge has heard both sides, weighed the claims, and concludes there's no issue worth taking to trial. That's a decisive ruling. The defendant's emotional argument, needing time, relying on family promises, is acknowledged, but it doesn't override property law. The court isn't deciding who was treated unfairly. It's deciding who has legal rights to the property. And here's where the judge shows balance. Instead of the standard 10-day move-out period, he extends it. That's not required. That's discretion. It's the court recognizing hardship while still enforcing the law. This is what makes rulings like this complex. It's not purely harsh, but it's not flexible either. It's controlled fairness within strict boundaries. Now consider this. If you were in that situation, would that extra time feel like relief or just a delayed consequence? Because at the end of the day, the outcome doesn't change. Only the timeline does.
The writ date would be the 31st. I will extend the writ date in this matter, given the circumstances, to August 7th. Thank you.
Thank you, Your Honor.
Okay, can you explain I don't really understand what that means entirely.
That means you need, normally, if I were to grant the judgment, just outright, I would have given you 10 days to move because I don't
yes,
have
sir.
an issue to try in this case. And so instead of the 10 days, I'm extending it out a week, trying to balance it a little bit based upon your needs to move and the tenants, the landlord's desire to have the property.
Okay, I appreciate that.
Right? Thank you. Properties versus Elijah Hendrickson.
Good morning, Your Honor. Hugo J. Mack appearing on behalf of 762 Properties.
Elijah Hendrickson, present, Your Honor.
All right. And this is a health hazard.
Yes, Judge.
All right. And Mr. Hendrickson, what's your position on the health hazard?
I filed an answer.
When?
When did
you file an answer?
Yesterday.
I don't have an answer. What?
Yesterday, Your Honor.
This is a procedural stumble that can instantly weaken a defense. The defendant claims they filed an answer, but the court doesn't have it. In legal terms, if it's not in front of the judge, it doesn't exist. Timing and filing accuracy matter just as much as the argument itself. The judge immediately questions where it was filed, and you can see the uncertainty. Wrong file, late submission, mailing delays, all of these create doubt, and doubt in court doesn't help your position, it undermines it. But here's where it gets interesting. The opposing attorney waives notice issues. That's a strategic move. Instead of fighting over technicalities, they're choosing to proceed on substance. That often signals confidence in their case. This moment highlights a core truth. Legal battles aren't just about being right. They're about being organized, precise, and on time. Engagement point. If you had a strong defense but filed it incorrectly, should the court still consider it? Or is procedure part of justice itself?
Where did you file it?
I sent it in online and it's getting mailed out this morning.
Well,
I put it in the wrong file.
you
There you
got
go. Yeah.
I haven't. Mr. Mack, do you have a copy of the answer?
Yes, Your Honor. I received an email of it yesterday. I'd waive any notice issues on this matter, Your Honor. We certainly got this late yesterday.
Okay. The basis for the health hazard is what?
Your Honor, in my pleadings, you'll see a report from RNA, which is a property maintenance, building maintenance company, where they tried to get in to deal with a roach bed bug infestation problem. And Mr. Hendrickson has repeatedly refused to allow access. When my process servers went to the home to knock on the door, there was never any answer. So, Your Honor, and then a real salient issue is there is no lease and this gentleman has paid no rent. So not only is there a health hazard, there's no lease and therefore he has no right to be there. So the health hazard.
That's not true.
Right here, the tension spikes. The landlord claims there's no lease, no rent, and a health hazard, a triple threat argument designed to justify immediate removal. But the defendant pushes back hard, directly contradicting the narrative. This is where credibility becomes everything. The landlord relies on a report from a maintenance company claiming access was denied. The tenant counters by saying they allowed treatment and even handled extermination themselves. Two completely different realities. And the judge is stuck in the middle trying to determine which one holds weight. But then comes a critical legal point. Even without a lease, the judge explains there may still be a tenancy. That changes the entire dynamic. You can't just remove someone because paperwork is unclear. Their occupancy still has legal standing. This is the courtroom forcing structure onto chaos. Engagement question, who do you believe here? The landlord with documentation or the tenant with explanations? And more importantly, what kind of proof would actually settle this?
I don't know how are you saying he got into the apartment then?
Your Honor, well, however he got into the apartment initially, I don't know. I wasn't representing my clients at that time, but the bottom line is there is no lease now, and there simply is no basis for its continued being there.
Well, that's not true, because if he came in under any color of title, somebody said he could live there, whatever, then he has a tenancy by default. It might be a tenancy at will, but he's got a tenancy. This is filed as a health hazard. So, I mean, he's got to correct the health hazard to the extent it exists. Mr. Hendrickson?
Yes, Your Honor.
Why won't you let them in?
I have let anybody in who has requested. They have not come to my property to deal with it. I have been assisted by another tenant in the complex who works as exterminator. He's treated my property several times. And the hazard was extant when I arrived at the unit. And I've been dealing with it since. I can provide witnesses to that fact.
Well, the landlord wants to treat the property. But are you letting him in, landlord, to treat the property?
I have no issue with that.
What, Mr. Mack, what day can they go in and treat the property?
Your Honor, I can consult with my client about that fairly quickly, but I need some clarification. My client informed me there is no lease, there is no agreement for this gentleman.
Okay, you can keep saying that. You have to tell me how he got into the apartment then.
Your Honor, I would have to ask my client that. How he got in there was before I got involved in the case. At best, this is a month-to-month tenancy, Your Honor. So if the court is saying,
that's what I said about 10 minutes ago.
All right. So if we have to refile on the month-to-month with a 30-day notice to quit, we'll do that. But we just felt the health hazard was the more appropriate way to go about it because there is health hazard. And Your Honor, with all due respect to what Mr. Hendrickson is saying, there is a report the court has from a reputable extermination company that says they have not been allowed in. Mr. Hendrickson is giving gratuitous statements to the court about he's got this and that. I see nothing in writing, Judge. Okay. So.
Okay. And all I'm asking is, when can they go in?
Your Honor, I will. All
right, look.
I will.
You guys get all of this together. I'm going to adjourn this out 1 week. July 28th, 2023, 9 a.m. I need a date that they can go in and do the extermination because that's what's in front of me.
The judge makes a decisive move here. Not a final ruling, but a controlled delay. And the reason is very specific. The only issue that matters right now is access for extermination. Everything else, lease disputes, payment history, arguments, gets pushed aside. The court narrows the case down to one actionable point. That's how judges manage complexity. Isolate the problem, force a resolution step by step. By setting a 1-week adjournment, the judge is applying pressure. Both sides now have a clear task: coordinate access and come back with results. No more excuses, no more confusion. This is also a subtle warning. If the parties fail to resolve something this basic, the court may take a much harsher stance next time. What's important here is control. The judge is steering the case, not letting it spiral into endless arguments. So consider this: when conflicts become too complicated, is the smartest move to solve everything, or just fix the one issue blocking progress?
Thank you.
Thank you, Your Honor.
Court calls the case, Blue Heron Point Apartments versus Takari Johnson.
Good afternoon, Your Honor. Sorry, good morning, Your Honor. Mark Land on behalf of plaintiff. Wishful thinking.
Ms. Johnson checked it.
So Carrie Johnson, they're not here. Would you like to take a default?
Your Honor, I believe that I've reached a conditional dismissal with Mr. Johnson, and I did email it into the court.
I do. Okay, I see it. And will both signatures apparently being there, I'll indicate this case is conditionally dismissed. Thank you.
Thank you, Judge.
Thank you. Court calls the case of Valley Ranch Apartments versus Jalen Burrows.
Mark Lander for the plaintiff.
Mr. Burrows?
I'm here. Can you hear me?
Yes, I got you. Okay. How much is owing on this?
Current balance, Your Honor, is $11,563.76.
And I think we were trying to, what do you have? Escrow at 8, 9, 4, 7. I mean, that's what I have. Well, I have 8. I have 8845. Yeah. You got to carry your 1.
8845.
Okay. So I have 8845 in escrow.
Wow, that's awesome.
Yeah. So the thing is, and this is a case, I know, Mr. Lando, you weren't here, but it was kind of, I guess, slow walking it for him to get to his, because he gets a commission check. Am I right, Mr. Burrows?
This is a completely different type of case. Not avoidance, but effort under pressure. The defendant isn't denying the debt. He's actively trying to pay it using escrow, commissions, even considering a 401k hardship withdrawal. And the judge recognizes that. That's critical. Courts respond differently when they see effort versus resistance. But here's the complication. The system itself is slowing him down. He needs documentation from the landlord to access funds, and he's not getting it. That creates a bottleneck where someone willing to pay can't actually complete the process. The judge steps in as a mediator here, not just a decision maker. He's pushing the landlord's attorney to cooperate and provide what's needed. This is where law meets practicality. The goal isn't just enforcement, it's resolution. Engagement question. If someone is clearly trying to fix the problem, should the system adapt to help them or stay rigid regardless?
That's correct. Yeah.
That's correct. Yeah. And so he was putting his money in escrow as he was getting it, but I think there's going to be a larger payment come mid-month, or help me, Mr. Burrows.
Yeah. So yeah, I get paid on the 10th. Well, I guess, and I get a weekly, but it's not much. So I get paid on my commission check every 10th of the month, unless that falls on a weekend. And that's where I can make, the more significant payment.
And we were trying to get ourselves, I think, to the August 10th payment. Is that right?
Yeah. I fell a bit short, but since we've last spoken, I've contacted Valley Ranch because I wanted to kind of just figure out a way to just get this all taken care of, at once, rather than having to keep doing this every week. But
is that his way of saying he doesn't like to see me?
No, you're fine. You're great. But no, I was going to take like a hardship withdrawal.
Right.
With
I
my
remember
401k. And in order to receive that, I need, pretty much in writing that, this amount needs to be paid. Otherwise, eviction, blah, blah, blah. But I never received that from Valley Ranch. I called them twice. Because they don't want me coming into the office because they think I'm confrontational. I know that's a surprise, but they never sent me what I needed. They told me they would have their attorney contact me. This was Wednesday. But I never heard anything. I actually called and left a voicemail, but haven't heard anything back. But I simply need pretty much just a document stating that, I have to pay this balance to avoid eviction.
All right, look, okay, I got you, Mr. Burrows. Mr. Landau, can we make that happen for him so he can try to get this withdrawal? Because he has done everything I've asked him to do that he could tell me he could do. We're 3108. It needs to be paid on the $11,000 balance. He comes in and pays the money. There is never an issue with that. He just has to get himself caught up. So
yes. So the answer to your Honor's question is yes, I'm happy to work with Mr. Burrows. I'll be candid with the court. My client has really been pushing me towards the eviction end of things, but I know your Honor's disposition on this, and Mr. Burrows clearly has been making best efforts and paying a substantial amount of money into the escrow. So
absolutely.
I would request the following. I would request that the court release the escrow to the plaintiff forthwith.
To have a deal. No. We're not going to do it that way.
Oh.
They may want to evict him. He has come here the last, I think, 2 times, told me the same thing that he was telling me today, that he's willing to do what he needs to do. He gets his check, and he had to remind me, it's the 10th of the month. And he puts his money in, and if they don't want to work with him, I'm not releasing anything till they work with him, give him the letter so he can get a hardship. That's the way I'm going to work.
This is a powerful moment. The judge takes control and draws a firm line. Despite the landlord's push toward eviction, the court refuses to release escrow funds until cooperation happens. Why? Because the defendant has shown consistent effort. He's appeared in court, made payments, communicated his plan. That earns him leverage, not legally in the contract sense, but in the judge's discretion. This is judicial balance in action. The court isn't ignoring the debt, but it's also not allowing one side to force an outcome without reasonable cooperation. The 1-week deadline is critical. It's a final opportunity to align, produce the required document, and move toward resolution. And the judge makes it clear, if that doesn't happen, the court will step in and decide the next move. This is no longer just a dispute. It's a test of who is willing to act in good faith.
So you guys got 1 week to get that done. I'll adjourn this out 28th. You know my position, so you guys make it happen. If it doesn't happen, then I'll figure out something else for Mr. Burrows.
If I can make one
request, and you guys can come try to find it. July 28, 2023, 10 a.m.
Can I make one note for that?
Please? Doesn't want to see me again, but he's going to have to.
Could I make one note for that document? I don't know if this is correct, if it could include this, but if it could have like the following month's rent on there as well.
The August
I can work
rent.
with you however you want, Mr. Burrows.
I'm sorry, I didn't hear that.
I can work with you however you want, Mr. Burrows. I've got your email address. I will follow up this afternoon with you. We will work together.
Okay, thank you.
This case ends not with a ruling, but with a direction, cooperation. After everything we've seen today, that stands out. Some cases collapse due to absence, others escalate due to conflict. But this one lands in a space where resolution is still possible. Across all these hearings, a pattern emerges. The courtroom isn't just about who's right or wrong. It's about presence, preparation, credibility, and effort. Show up, bring proof, follow through, and your chances improve. Miss those elements, and the system moves past you quickly. We've seen default judgments, failed negotiations, procedural mistakes, and strategic delays. Each one reveals how the legal system operates under pressure, structured, efficient, and often unforgiving. The final takeaway is simple. The courtroom rewards action. Not intention, not excuses, action. If you found this case as revealing as it is intense, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.